Several of these testifiers represented that the legislation was unnecessary because the information and tools required to allow repairs by equipment owners or independent repair providers is already available. Granser, manager of customer support for John Deere in the U.S. and Canada, stated, "We support customers' ability to repair their machines, and we certainly provide all the tools that are required." He further stated that we don't believe we need legislation to enable customers to repair their machines. We've already enabled that. And Willie says, "I love the notion that this false testimony is a justification as a mitigating factor for why the proposed legislation is deemed constitutional." So what they're saying over there is, listen, if you've already agreed to make all of this available, then you should have no problem with this legislation that says you're going to make everything available. And Willie is saying, listen, I love the fact that you lied is actually justification for the bill. I think that's hysterical, and Willie and I both started laughing at the same part. Hey everybody, how's it going? Hope you're having a lovely start to your week and a lovely Monday morning. Today, I wanted to circle back around to this video that I did a month and a half ago. Nebraska farmers are getting effed. Here's how. In that video, I was going over how strange it was that the Nebraska Farm Bureau voted 176-1 in favor of supporting right to repair, yet every single time they endorse a politician, they seem to endorse a politician that votes against right to repair. Here, I gave examples of several senators that were not endorsed by the Nebraska Farm Bureau, that were urban city Democrats that probably have never seen a tractor in their life, that all voted in favor of right to repair. And then you have a bunch of Republican senators that were endorsed by the Farm Bureau that represent rural farmer districts that voted against right to repair. And I just wanted to bring this point up and demonstrate how they're getting screwed. You have people that say, we're for farmers, yet when they actually vote, they vote against farmers. And I wanted to bring some visibility to this in the hopes that that pattern changes. Now, there was one particular senator, Julie Slama, that gave reasons as to why she was against this bill that, in my opinion, were not grounded in fact, and in my opinion, missed the big picture entirely. It really seemed very strange and very weird that everybody who was endorsed by the Nebraska Farm Bureau voted against the interests of actual rural farmers in the district. Now, as I said, from a big picture and principle point of view, I disagreed with the response from the senators that voted against it. But as I've said on this channel many times, I am not a legal scholar. I cannot tell you the specific legal reasons as to why what they said when they say this bill is unconstitutional is wrong. However, there is somebody who is qualified to say that, and that is the Attorney General in the state, who has went over all of this. My apologies for this very poorly formatted PDF. It kind of got messed up when it got converted over here, and the image recognition thing. See, there's going to be a little bit of Babelfish over there. This is from Douglas J. Peterson, who is the Attorney General, and Lieutenant J. Bartle, the Assistant Attorney General. So I'd like to read the highlighted portions of this, and I want to thank Willie Cade for bringing this to my attention so that you can understand the actual legal arguments as to why it is this is not an unconstitutional bill. And you can let me know what you think in the comments down below. So it says the act would require an OEM of electronics-enabled agricultural equipment to make available for purposes of diagnosis, maintenance, or repair of such equipment to any independent repair provider or to the owner of electronics-enabled agricultural equipment manufactured by or on behalf of or sold otherwise by the OEM on fair and reasonable terms, documentation, parts, tools, inclusive of updates to information or embedded software. To be clear, not source code, simply the payload file that is used for the device. So if we scroll down over here, let's just see what they have to say. So the first thing he does is respond to Senator Julie Slama, who voted against the bill. He says, "We assume your concern is directly related to the Act's potential impact on end-user license agreements governing the use of embedded software in electronics-enabled agricultural equipment." His analysis. Article 1:16 of the Nebraska Constitution provides that no law impairing the obligation of contracts shall be passed. A three-part test is applied to determine whether a contract has been unconstitutionally interfered with. So, he says, impair means to make worse, operated as a substantial impairment. In order for there to be an impairment, the change must take away something and not work to the party's benefit. And he does include a lot of citations here. He is not just simply pulling this stuff out of his ass, which is what I would expect of an attorney general as opposed to some random YouTuber like me yelling into a camera. While the contract clause is facially absolute, its prohibition must be accommodated to the inherent police power of the state to safeguard the vital interests of the people. And he brings up specific citations of case law, which is nice. Is whether the state law has in fact operated as a a substantial impairment on a contractual relationship. If the state regulation constitutes a substantial impairment, the state, in justification, must have a significant and legitimate public purpose behind the regulation, such as remedying of a broad and general social or economic problem. Whether the adjustment of the rights and responsibilities of the contracting parties is based upon reasonable conditions and is of a character appropriate to the public purpose justifying the legislation's adoption. Now it says, is customary in reviewing the economic and social regulation, courts properly defer to legislative judgment as to the necessity and reasonableness of a particular measure. Does the act substantially impair existing contracts? In considering whether a state law operates to substantially impair a contractual relationship, a court will consider the extent to which the law undermines the contractual bargain, interferes with a party's reasonable expectations, and prevents the party from safeguarding or reinstating his rights. To the extent that such an agreement includes prohibitions or limitations on access to or use of embedded software by an owner of an electronics-enabled agricultural equipment for purposes of diagnosis, maintenance, or repair, or access to or use of such software by any independent repair provider, the Act would appear to alter those contractual terms. Such a change could be a substantial impairment of the parties' contractual relationship, which would undermine the OEM's ability to safeguard its contractual rights. On the other hand, the Act requires that owners or independent repair providers be given access to documentation, parts, and tools, inclusive of any updates to information or embedded software, only for purposes of diagnosis, repair, or maintenance of the equipment. The EULA identifies the licensor's right to protect its proprietary licensed materials under copyright and trade secret law and restricts the licensee from attempting to modify licensed material or to reverse engineer or attempt to create the source code from the object code for the software. The Act's limitation to access only for the purpose of diagnosis, maintenance, and repair and preservation of trade secret rights appear to be consistent with these contractual terms, protecting trade secrets and prohibiting modification or recreation of source codes. So this is a point that was brought up by C.T. Wilson in Maryland, which is that we are looking for source code. We want your source code. Why would you need your source code? And here you have the Attorney General reading the bill out loud, and when he reads the bill, he specifically says that the bill appears to be consistent with the contractual terms protecting trade secrets and prohibiting recreation of source code, which is as clear cut and dry as you can get it. So there you have it. This cuts directly against that point that everybody keeps talking about, which is that this bill would require you to release source code, which it clearly doesn't. As right to repair legislation dates back to 2012 and has been introduced and considered in many states since 2015, OEMs of electronics-enabled agricultural equipment should have recognized that their EULAs or similar agreements could be impacted by such legislation. Several of these testifiers represented that the legislation was unnecessary because the information and tools required to allow repairs by equipment owners or independent repair providers is already available. Granser, manager of customer support for John Deere in the U.S. and Canada, stated, "We support customers' ability to repair their machines, and we certainly provide all the tools that are required." He further stated that we don't believe we need legislation to enable customers to repair their machines. We've already enabled that. And Willie says, "I love the notion that this false testimony is a justification as a mitigating factor for why the proposed legislation is deemed constitutional." So what they're saying over there is, listen, if you've already agreed to make all of this available, then you should have no problem with this legislation that says you're going to make everything available. And Willie is saying, listen, I love the fact that you lied is actually justification for the bill. I think that's hysterical, and Willie and I both started laughing at the same part. The testimony on behalf of manufacturers and dealers representing that the information and tools needed for owners or independent repair providers to repair the agricultural equipment is already widely available seems incongruous to any claim that providing access to that information impairs current contracts. So the fact that John Deere has lied about making this information available, which I will include a link to in the description down below so that you can see, is actually hurting them, because they're saying, wait a second, if you made all this stuff available that people need to repair stuff, then why are you saying that you can't make stuff available to people? Like, they got caught in their own lie by the Attorney General, and I hope somebody's paying attention to that. The Act's definition of repair is consistent with this concern, as it excludes any activities that result in the machine being modified outside of the original equipment manufacturer specifications. Manufacturers did promise to provide these tools by January 1st, 2021, and they have not held up their end of the bargain. While opponents of the bill testified that such information and tools were in fact available, this further demonstrates that OEMs may be hard-pressed to challenge the Act's requirement that they provide access to software solely for diagnosis, maintenance, or repair, or that it impairs any constitutional rights. In sum, it is not clear that the Act would substantially impair existing contracts. These factors may support finding that any impairment of these current agreements is not substantial, which just pretty much takes what Julie Slama was saying as a reason for not voting the bill and invalidates it entirely. As it is unclear that the Act would substantially impair existing contractual obligations, we will proceed to address the second step of the contract clause analysis, whether the Act has a significant and legitimate public purpose. The requirement of a legitimate public purpose guarantees that the state is exercising its police power rather than providing a benefit to special interests. The contract clause prohibits special interest redistributive laws even if the legislation might have a conceivable or incidental public purpose. LB 543 contains no legislative findings or statement of purpose. While it would be preferable for the Act to contain findings and a declaration of purpose, the history is some evidence to establish the significant and legitimate legislative purposes served by the Act. It also serves broader, significant, and legitimate public purposes. Agriculture is of vital importance to Nebraska's economy. It would also address concerns regarding monopolistic practices in the market for repair of agricultural machinery. On balance, it appears the Act served a legitimate and significant public purpose. Because the state is not a contracting party, deference is due to the legislative judgment of the reasonableness and necessity of the Act. As noted above, the Act serves the substantial and legitimate public purposes of ensuring agricultural producers and independent repair providers have the right to repair agricultural equipment in a timely manner, which will benefit farmers and businesses of rural communities, and promoting competition and removing monopolistic practices in the market for repair of agricultural machinery. Conclusion. Other factors, including the foreseeability of the enactment of right to repair legislation impacting these agreements and representations made on behalf of manufacturers and dealers that such information is already available, further reduce any claim of impairment to existing contract. This Act serves significant and legitimate public purposes. Finally, the Act is reasonable and appropriate means to serve these purposes. We therefore conclude that the Act likely does not violate the contract clause. Again, this is not coming from a biased pro-right to repair YouTube repair shop owner. This is not coming from a farmer. This is coming from the Attorney General in the state of Nebraska. So the TLDR here, A, it does not violate the contract clause. B, the fact that the manufacturers have said they've already made all this stuff available is actually being used as ammunition against them for why they're against the bill. If you've already done what this bill is asking you to do, then you should have no opposition to it whatsoever, and you should have no problem with it. That coming back to bite them in the ass, I thought was particularly interesting. And what I really like to see now is whether or not the individuals who voted against this bill based on the contract clause and constitutionality change their tune now that the Attorney General, who has more knowledge in this area, has gone over it and said, you're wrong. If they do change their vote, then credit to them. They made a mistake and they corrected it. That's fine. If they don't change their vote and they keep using the exact same copy and paste reasons that I talked about in this video, then you'll kind of have an idea of exactly what it is that's going on there, and I would suggest that you vote them out accordingly. Let me know what you think in the comments down below. That's it for today, and as always, I hope you learned something. I'll see you all in the next video. Bye now.